Okay, folks, this is criminal defense attorney Nate Amendola. Today, we're going to be discussing the probable cause standard in a Massachusetts domestic violence case. The first thing you need to understand is that probable cause is the standard that the police need in order to make an arrest out in the field. Okay? In short, probable cause means that there are trustworthy facts that would lead a reasonable person to believe that a crime is being committed. It does not mean you're guilty. What you need to know is that in Massachusetts, when the police respond to a call for domestic violence, arrest is the preferred method. Doesn't mean they have to, we're going to talk about it in a second, but it's the preferred method. This is even true if the alleged victim doesn't want to press charges. That's why the vast majority of domestic violence calls end up with somebody being arrested. There are situations where the police have to make an arrest, okay? And that's when somebody has violated a restraining order, which is civil in nature, okay? But if you violate it, it's criminal in nature. Now, in making a decision to arrest somebody on a domestic violence call, the police will use their five senses to determine if there's sufficient probable cause to make an arrest. So let's talk about that a little bit. The police will consider things like whether there have been attempts to cancel the original call. They'll look around and use what they see at the scene. Are there obvious things like weapons, broken furniture, physical injuries? Is somebody crying? The police will also talk to both parties and listen to their version of events. The police may also consider an alleged aggressor's criminal background. It's really important to remember that if you've been arrested for domestic violence, it doesn't mean you're guilty. It just means at that moment, the police believe there is probable cause to arrest you for domestic violence. The determination of guilt or innocence comes later at trial. And it's possible your case may never get to trial. There are lots of things a good lawyer can do to get rid of or dispose a domestic violence case before trial. Maybe, for example, there's a legal problem with the sufficiency of the probable cause determination made by the police. Maybe the alleged victim has a Fifth Amendment issue, meaning that he or she, for some reason, cannot testify, or that he or she has a marital privilege that would prevent him or her from testifying.